be entered into through what we call an agreement, under which the insurer is actually legally bound to compensate the other party in case of an occurrence of a loss or an event at a future date. And it can actually only happen, that compensation can only happen if you have what we are calling an agreement. Mostly, it is normally actually in writing. It is mostly normally in writing. So you'll be able to fill out the forms, basically seeking for that particular insurance policy. And that particular form will likely be able to form an agreement or a contract between you, the insured, and of course, the insurance company, or basically the insurer. So for any insurance contract, there should be what we call an agreement. So in case of, for example, default in payment of compensation, then there's actually a basis under which any of the parties under the contract can actually be able to come before the court and actually hold the other party responsible. So for insurance contracts, there must be what we call an agreement between the insured and the insurer, or basically the insurance company and the insured. And then there's what we call uncertainty, is actually another key essential. So most of the events that are normally insured, or basically these particular events you're talking about, that they'll happen at a future date, they're usually very quite uncertain. So you can't actually be able to tell when they'll actually happen. So basically there is what we call just speculation. There's just speculation. You're just basically taking the insurance policy in terms of health for speculation. So you are not actually sure whether you fall sick or not, but in case it actually occurs, then this particular insurance company should actually be able to compensate you. So for insurance contracts, so they are usually basically speculative in nature and basically deals with uncertain future events, basically events which you cannot actually be able to predict. So for example, a person takes a life policy or life insurance policy. So in case of death, this particular person will actually be compensated, or basically the family will actually be compensated with a particular sum of money as agreed by the insurance company. So in this particular aspect, basically the event you are basically taking insurance for, it is not quite certain. You're not actually sure when it will happen. If it is a motor vehicle insurance policy, you don't know basically, for example, when this particular person will likely be involved in an accident. So these events are just basically uncertain. They are speculative in nature. So that is one key aspect, or basically one key essential of an insurance contract. So the events that are normally insured under an insurance contract are usually speculative, or you can be able to say they are usually very uncertain. So you can't be able to tell when they'll happen. You can't be able to tell when they'll actually happen. You can't be able to tell when they'll actually happen. So that is one key essential of an insurance contract. Another key thing about an insurance contract, there is what we call insurable interest. Insurable interest. This is what we call insurable interest. Insurable interest. This is what we call insurable interest. So the party or the person basically who's taking up the policy should have the interest, for example, in the subject matter that is basically being insured. So for example, if it is property, for example, if it is a house, you are insuring it for, let's say, for example, a disaster, against a disaster, like let's say, for example, floods or maybe fire. So the party we are calling the insured should have what we call insurable interest. And this one can actually basically be gained, for example, if it can be ascertained that, for example, you have a title of this particular property. So anything that is basically being insured, or basically the subject matter that is actually being insured, the insured party should actually have what we call insurable interest. So you must actually be having an interest over the subject matter before it can actually be ascertained, or basically they can proceed under the contract or agreement. For example, if it is maybe a matter to do with health, in this case, basically you are the one taking up this particular policy in terms of health. So you have what you are calling an interest in the subject matter that is actually being insured. So there should be what we call insurable interests. And in this case, it will be able to arise if it can be ascertained that the insured has an interest in the subject matter. Maybe he's actually the owner of the motor vehicle, or basically is the owner of the property, as we've said, for example, in the case of a house, that particular house is being insured against a disaster like flood. So who will be the insured party? So it must be ascertained that the insured party has what we call insurable interest. For example, they could ask you for the ownership, the title of ownership. If it is a motor vehicle, probably it is a logbook. If it is basically land, for example, in this case, it simply means that it is actually maybe your title. So there must be a direct interest that the insured party has over what we are calling the subject matter that is being insured, the subject matter that is being insured. So there's what we call control.
Excuse me, Wally.
Yes.
There is some students outside.
Or there are students who are still out. Or Mokaya, I can see Mokaya. So I think I've been able to admit her, Mokaya. I think I've let Mokaya in. So you are saying there's what we call control. So control is another key essential under an insurance contract. So the insurable event must be beyond the control of the party assuring the risk. So that event you are basically taking insurance for, it should actually be ascertained that that particular event will basically be beyond your control. You can't be able to control it. If it is an accident, basically you are not actually able to control. So it's something that is basically you have no control over. So these events, most that are normally insured, you'll be able to realize that the party insuring it, or basically the person who's actually basically taking up the insurance policy, he has no control over them. For example, if it is an insurance to do with maybe health, so you can't actually be able to tell when basically you'll be ill, and you can't actually be able to control such kind of a matter. So it simply means that once it arises, then it should be an event that you, the insured party, or the person taking up the insurance policy, you have no control over. If it is basically a flood, so you can't be able to tell, it is by nature of God. So you have no control over this particular event. So the insurable events must be events that are basically beyond the control of the party assuring or taking up the insurance policy. So that is basically another key essential that is usually present in insurance contracts. The events that basically are being insured, or this particular person is basically taking up the insurance policy for, they should be events that are basically beyond the control of the insured party. So that is a key essential that is usually present in insurance contracts or insurance agreements. So we have what we call risk. So risk is actually also another key essential to do with the insurance contract. So the events basically are being insured, they basically look at what is the chance that they are likely to arise. What is the risk that they are likely to arise? And probably this is basically what the insurance companies are actually able to use to be able to ascertain as what will be the amount in terms of payment of the premiums. So the risk of that particular event actually happening should actually be ascertained, So what are the chances of this particular loss or this particular event actually occurring? So what is the probability of the outcome of this particular event actually occurring or not actually occurring? So this particular condition or this particular ascertainment of the possibility of this particular events actually happening basically will actually be able to lead to the insurance company being able to ascertain as to how much you can actually be able to pay as premiums. Probably, for example, if you've taken any insurance policy to do with maybe, let's say, for example, health, they could actually look at maybe your health history or your health history. So they are basically asking whether you are basically have suffered or previously suffered from a terminal disease, so that they can be able to weigh the chances. For example, do they basically give you the insurance policy at a particular premium, or maybe a lower premium or a higher premium? Because in this case, if a person has been suffering from a terminal disease, there are higher chances that the insurance company will likely incur a lot in terms of having to pay for the health of this particular person. So maybe if you take the insurance policy for maybe each and every year, you are paying, for example, premiums of a total of maybe 200,000. So there are chances that, higher chances that probably in that particular year, if they look at the chances or the risk or the probabilities, basically this particular person might be ill or maybe twice in a year, and probably could actually be admitted in a hospital. So they could actually basically end up incurring or having to pay a bill of, let's say, for example, 500,000. So what is the risk of the insurance company actually basically benefiting from the premiums or not actually benefiting at all? So probably if you paid 200,000 as premiums in that particular year, then this particular person, you are saying that is admitted twice in a year in a hospital, whereby basically they spend like 500,000. So you can see the insurance company will likely basically be in a deficit or a negative. So that's why they basically have to employ actuarial scientists to be able to ascertain what are the probabilities, what are the chances when they are basically ascertaining or basically coming out with the premiums that can actually basically be paid by their clients or customers. Probably there could be another party who basically has paid that particular 200,000 as premium, but the whole of the year, basically he doesn't actually even fall sick, not even having to be admitted in the hospital, but the premiums have actually been paid. So it is just simply a game of chances. It is just simply a game of chances by the insurance company. So those basically won't actually basically fall ill. So they'll basically retain their premiums, maybe to cover for other parties. So maybe out of 5 people, if they pay the premiums of, let's say, for example, 1,200,000 each, 1 million in a year, the chances are that basically only 2 will actually be able to fall ill, and probably they could end up incurring a bill of, let's say, for example, maybe 700,000. So they'll be able to retain the 300,000 in terms of maybe profits for at their end. So risk is usually very important in insurance contract. What are the chances? What are the probabilities of these uncertain future events actually happening? So that one basically can actually be ascertained. So they have basically to ascertain it as an insurance contract by engaging the persons we are calling actuarial scientists. So risk is actually an important element.
One.
Yes?
There is another one outside.
There's another one. Okay, I think I've allowed them. So those are the key essentials. So those are the key essentials of an insurance contract, or some of the elements that will be present in what we are calling an insurance contract. So maybe you can add the last one, accidental. So the event should actually be accidental in nature. So the event should be accidental. So the last one should be accidental in nature. So that particular event should actually be accidental in nature. So not that basically you by yourself just drove your car and hit maybe a tree and you expect the insurance company to pay. No, so they won't actually pay. So the event that you're talking about, that particular disaster or floods, it should be accidental. It should actually be ascertained it was actually accidental in nature before the insurance company can actually be able to pay. So insurance can only be able to be effected where the loss is actually accidental in nature. So the insurance will only be effected, that agreement will only be effected where the event that you're talking about, the uncertain future event you're talking about, is accidental in nature. So these are the key elements that should actually be present in what you're calling an insurance contract, You can see Beatrice is stuck out. I don't know, it's internet at her end or what, but I can see she's stuck out. So we can look at the formation of an insurance contract. So how is it actually formed? How is it actually formed? So for any contract, as we saw under the law of contract, there should be what we call an offer and an acceptance. So there should be what we call an offer and an acceptance. So there will be what we call an offer, and this particular offer will be by the insured party. Then we'll have the acceptance by the insurer or insurance company. Remember what will happen in this case, the insurance company or the insurer will just present the form, So that is basically giving out of the form. So after this particular form has been given, is when now we are saying now the insured party is actually basically giving an offer. So by completing that particular form, you as the insured party, you are simply now giving the offer to the insurance company to be able to accept. So they can either accept, or basically reject to insure you as a party. So because you can be able to fill the details, they assess, so they see basically the risk is so high, so they can't be able to take you in their insurance policy. So probably they'll actually be able to reject. So there's usually an offer and an acceptance. So the offer basically is actually made by the insured party by filling out the form. So when you fill out the form is when now you are making the offer to the insurance company. So once the insurance company goes and actually assesses these particular documents that you've submitted, so that's when they'll be able to either accept or basically reject your offer in terms of as to how much you're going to pay as premiums or which insurance policy or cover you want to be covered for in that case. So the form will actually include things like, let's say, for example, in that particular form, you fill particulars. So there'll be the particulars of the proposer or the offerer. So there'll be the particulars of the proposer, particulars of the proposer or the offerer. So that is the person taking up the insurance policy. So you'll be able to fill there your details. So that is your name. So all those details will actually be included there. So particulars of the subject matter that is being insured. So what are you insuring? Is it a health cover? Is it maybe a house against a disaster like fire? So particulars of the subject matter that is being insured. Particulars of the subject matter, particulars of the subject matter being insured. So the particulars of the subject matter being insured. So if it is a house, you'll be able to describe it, that this particular house is located at Runda Estate. So street number 4, house number 7. So you'll be able to ideally give the details of the subject matter that is being insured. So that is the house you are insuring against what you are calling fire or maybe floods. Also, there'll be the circumstances affecting the risk of the subject matter. Circumstances affecting the risk. So for example, if it is health, as I've told you, they'll be able to look at your health history. So are you suffering from any terminal disease? So they'll ask there. So you either tick yes, or maybe you tick no. So these are some of the particulars that basically will be found in the what you are calling that particular proposal form or that particular form. So once the insurance company actually gets the form, then they'll be able to communicate formally, maybe via email, or maybe via mail, or maybe via a text message that basically they have accepted you to basically take up their policy. So by formal communication or just simply by conduct or how the insurance company actually carries out itself, probably they could issue or give out what we call an insurance policy. So that insurance policy basically will be the conclusion that they have actually been able to, maybe accept the offer that you've actually given them. So that is basically how this particular insurance contract we are saying will actually be formed. So I want us to look at the principles of an insurance contract. Principles of insurance contracts. So principles of insurance. So number one, we have insurable interest. So insurable interests is one of the principles. Insurable interest. Utmost good faith. Utmost good faith is another principle. Utmost good faith. Utmost good faith. Sometimes we say uberimae fidai. Contract uberimae fidai. Contract uberimae fidai. Uberimae fidai. Contract uberimae fidai. So utmost good faith is another principle, so we'll be able to explain them. We have indemnity. Indemnity. We have the principle of subrogation. Indemnity, you have the principle of subrogation. So indemnity, subrogation. We have salvage. So number 5, we can talk about salvage. The principle of salvage. Number 6, principle number 6. We have double insurance. Principle of double insurance. Then you have the principle of apportionment and contribution. 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 And then they have the principle of proximate costs. The principle of proximate costs. The principle of proximate costs. Principle of proximate costs. The principle of proximate costs. Then you have the principle of reinstatement. Reinstatement. So these are the major principles under an insurance contract. So I think insurable interest we've tried to explain under the essentials of a valid insurance contract. So we are saying that under insurance contract, all insurance contracts, the insured party must be having what we are calling a direct interest in the subject matter. For example, if it is a house that is being insured, then probably you are the owner. So there's no any other party will basically be able to come and insure the house, but basically it should be insured in your name. So there should be what we are calling insurable interest. So there should basically be what we are calling a stake at risk. And of course, you have the title to this particular stake that basically if an event actually occurs, then probably you're actually at a loss. So this is basically like, for example, the financial or basically the monetary interest that a person basically will have in the subject matter. So it is the financial. So the subject matter in this case simply means that the person taking up the insurance policy must be having financial interest or monetary interest in the subject matter, must be having financial interest or monetary interest in what you are calling the subject matter. As we have explained, the subject matter in this case, we mean, let's say, for example, a house or, for example, a motor vehicle that you're insuring against maybe a fire or maybe an accident. So you have an insurable interest. So you have basically financial interest or monetary interest, such that in case of any danger, if this particular subject matter is actually destroyed, then probably you'll be at a loss as a person. So there should be what you are calling insurable interest. So this one will have to be ascertained before even, let's say, for example, the insurance company actually does what you are calling compensation. Or for example, before actually they enter or basically accept your offer for the application. So do you have a financial interest in this particular subject matter? Do you have the ownership or the title? So they'll be able to ascertain this probably before even they actually accept the offer you've given them of taking up the insurance cover or policy. And probably you are saying in the simple way they could be able to ascertain this by being able to know whether you have the ownership or the title to the subject matter. So that particular principle is actually very important in insurance contract. So principle number 2 that we're talking about, it is known as the principle of utmost good faith. Sometimes it is actually known as the principle of uberimae fidei, or uberimae fidei basically is actually in Latin. So it simply means utmost good faith. So in this case, what we mean by this, the disclosure of basically information to do with, let's say, for example, taking up the insurance cover or policy by the insured party, it is basically taken or basically presumed by the insurance company that you'll be able to act in what you are calling utmost good faith by giving out the information. For example, if they ask probably if you've been suffering from a terminal disease, this one basically can only be ascertained by you. And of course, you are the one who can actually be able to give out this particular information. So it is expected when you are giving out this particular information, because it is hard for the insurance company to easily basically ascertain at that particular moment, you are expected to act as the insured party with what we call utmost good faith. Because if there's a discovery that maybe you didn't actually act in good faith or gave out the proper information with regard to taking up the insurance policy, then the insurance company can be able to take certain actions. So it is expected, or basically it is the duty to disclose basically throughout the negotiation process the relevant information that can actually basically lead to the formation of the contract of insurance, of the contract of insurance. So for example, in this case, the insurance company will be able to tell you that in case this one actually happens, we'll compensate you fully for the house. So some of the things they basically tell you, probably you are not actually able to ascertain its truths. You simply basically rely on them to be able to give maybe the right information. That information you basically are giving out to the insurance company, maybe sometimes it is not factual, and probably it is not easy for the insurance company to be able to ascertain. It is expected that during this particular negotiation process, you both parties, the insured and the insurance company, you'll act in utmost good faith in basically giving out information or disclosing information that will be able to form the basis of this particular contract or agreement, this particular contract or agreement. So that is basically what we mean by the principle of utmost good faith, the principle of utmost good faith, that you'll act with utmost good faith in the disclosure of information during the negotiation process, And then we have the principle of indemnity. What we mean by indemnity, indemnity simply means to compensate. So basically, in this case, what it means that in case a loss actually occurs, it is basically the duty of the insurer to be able to compensate the insured party for the loss that has actually occurred. So the insurer should actually basically be able to restore the insured party to the original position that he was, before the loss actually, or basically the accident actually occurred. If it is a motor vehicle, then probably a new car can be given, or basically that particular car that has an accident can actually be repaired. And in this case, the insured party will be compensated, will be indemnified. So that is basically what it means, that by that particular principle, that the insurer will be able to compensate or return the insured party to the original position with regard to the subject matter under the insurance in case of any loss that has actually occurred, in case of any loss that has occurred. If it is a house that was insured against a disaster like fire, so probably in this case, it simply means that in case of that disaster actually happens accidentally, then this owner of the property or this owner of the house will be returned to the original position by being given basically a new house, or basically ensuring the house is in a good condition. Then we have the principle of subrogation. The principle of subrogation. So what it means by this, in this case, in case of a loss, what will happen? The insurance company normally steps into the shoes of the insured party under certain circumstances. Let's say, for example, if it is a motor vehicle that has basically been destroyed, and of course, in this case, they have to give a new motor vehicle. So they'll give the new motor vehicle, but of course, they'll step into the shoes. They'll step into the shoes of the insured party by taking up the old vehicle. They'll basically be subrogated. They'll be subrogated as the insurance company. As they take up the motor vehicle and write it off, probably they could actually be able to sell this particular motor vehicle that has been written off. And on the other hand, they'll give this particular insured party a new motor vehicle. So you can see the insurance company is simply stepping, it is simply being subrogated of the rights of the insured party over the property or over the subject matter. If it is a house that has basically been destroyed beyond basically repair, so they could actually basically take up the wreckage of the house, or basically take up this particular property, and of course, give the insured party a new house somewhere else. So as basically they give the new house, they basically step into the rights of the insured party. They are basically subrogated by the rights of the insured party over the subject matter that has basically been destroyed, which had actually been insured. So they take up the old property as basically they give out a new property. That is basically what we mean by this particular principle known as the principle of subrogation. They simply step into the shoes of the insured party over the rights over the subject matter. They take up the old house like it's theirs. It's like that particular house is theirs for the insurance company. And they take over all the rights in terms of ownership of that particular house, as basically they give out a new house to this particular party who has basically incurred a loss, or the insured party. So there's normally that particular principle we are calling the principle of subrogation. So it simply means that the insurer will basically be indemnified, while the insured basically, the insurance company basically steps into the shoes of the insured in relation to the subject matter, or the rights over the subject matter. So it takes up the rights over the subject matter, as of course now in this case, the insured party is actually given a new property, is given a new property. And then we have the principle of salvage. So the principle of salvage. So the principle of salvage. So what do you mean by this? The remains, it's almost similar to this one. It's almost similar to this one. Only this one, basically subrogation, we are emphasizing on the rights. We are emphasizing on the rights. We are emphasizing on the rights. So what do you mean by the rights? In this case, for example, if you are staying in that particular property, the insurance company can actually be able maybe to take over the property in terms of all the rights. So they can be able to walk there and have all the rights over the property. So that's what we mean by subrogation. So they step into the shoes of the insured party with regard to the rights over the subject matter. But for the salvage value, what we mean by this, now in this case, they simply take over the salvages or the remains of any wreckage or basically property that was actually basically insured. So the remains of the subject matter will basically be taken up by the insurance company. So it is the recovery by the insurer of the remains after the indemnity, or basically the indemnity has actually been paid.
Excuse me.
Yes.
Teacher, let
Yes.
someone in. Let someone in.
Okay. So I can see it is Sasha. So I think I've let her in. Let's see if. So I think she has been able to come in. So that is what we mean by salvage, the recovery of the insurer of the remains of the subject matter after indemnity. So while this one actually emphasizes on the rights, subrogation, this one basically concentrates on what you are calling the remains. You can be able to just combine them and say the principle of subrogation and salvage. The principle of subrogation and salvage. So while you take up the remains, you also take up the rights over the remains. You take up the rights over the remains, the rights over the remains. For example, the title to the property will likely be taken up by the insurance company because they have given already a new subject matter, a new property to the insured person, And then we have the principle of double insurance. By double insurance, we simply mean that, or this particular, it's a particular situation whereby one subject matter is actually basically insured twice. Is insured twice with two different insurance companies. So it is whereby a party takes out actually more than one insurance policy for one subject matter, or basically over the same subject matter. If it is a house, basically could actually go to a different insurance company and of course, maybe take up the policy and also go to another insurance company and take up a similar policy with them. For example, if it is fire, so maybe you go to UAP as an insurance company, you take up an insurance policy for fire. You also go to Jubilee and actually do the same. If you do such, basically you say you've done what you are calling double insurance. So double insurance is whereby a party actually takes up more than one insurance policy over the same subject matter, In this case, we are saying the subject matter basically it could be health. You take up with two insurance companies. It could be a house, you take up with two different insurance companies. It could be a motor vehicle, you take up with two different insurance companies. So just depending on your needs as a person or as a party, in case you want to take up any insurance policy or you enter into an insurance contract or agreement. So now this particular one you are calling double insurance, it is in relation to apportionment and contribution. So let's say, for example, you've taken up two insurance covers over the same subject matter. In case of a loss, they'll basically be what you are calling apportionment and contribution. Apportionment and contribution. So they'll be able to do the mathematics, do the calculation. These two insurance companies, now that this particular event has happened, this uncertain event has happened, this particular uncertain event you're calling a disaster of fire has happened over the house. Since two insurance covers had actually been taken over the same subject matter you're calling the house. So how will be the apportionment in terms of compensation? So that one basically will actually arise, contribution and apportionment will actually basically arise in case of what you are calling double insurance. And it is simply whereby we are saying they'll be able to apportion or ascertain as to how much each and every insurance company or insurer is actually able to pay in terms of any loss that has occurred or uncertain event that has actually arisen, and there's a loss to be paid or be compensated or be paid to the insured party, So that is basically what we mean by double insurance and of course apportionment and contribution. Then you have the proximate cause. The proximate cause. What do you mean by the proximate cause? Before the insurance company actually pays, so they have to ascertain what was actually the cause. If it is an accident, was it intentional or not? That particular cause that actually basically led to the loss, is it in relation to what had actually been insured? So they have to ascertain what was actually basically the cause or the proximate cause, or basically that particular reason that led to the loss. Is it near to what was actually being insured as the reason that can actually basically lead to a compensation? So they have to ascertain what you are calling proximate cause before they do what you are calling compensation. So the insurer only will be liable where the loss is proximately caused by an insured risk. So that insured risk that had been insured, so if that loss has been basically caused by the insured risk. So they have to ascertain what actually led to the loss before they do actually what you are calling compensation. So reinstatement is just the same as, let's say, for example, indemnity, just the same as like indemnity. So they'll basically return the insured party to the original position. They'll be able to reinstate. To reinstate is to return someone to the original position. So this is the repair or replacement of the subject matter in circumstances in which it may be reinstated. So you'll be able to do what you are calling repair. For example, there's a motor vehicle windscreen, it will be repaired and return this particular motor vehicle to the original position where it was actually before the accident. So that is basically the principles. Those are basically the principles of insurance, the principles of insurance. So probably they could bring a scenario and they ask you, what are some of the principles of insurance you can be able to discover from the scenario that has been given? So you should actually be able maybe to relate it to insurable interest, utmost good faith, indemnity, subrogation, salvage, double insurance, apportionment and contribution, proximate cause. The reason that actually basically led to the loss actually occurring has to be ascertained by the insurance company before they do the compensation or payment of the loss of the subject matter. Reinstatement, they'll be able to do a repair or basically simply return the insured party to the original position. They'll be able to return him to the original position. So I want us to look at termination of an insurance contract. How basically does an insurance contract actually come to an end? How does it actually come to an end? So termination of an insurance contract. Termination of an insurance contract. So termination of an insurance contract. So it can come to an end through the payments or payment of the indemnity. Payment of the indemnity. So payment of the indemnity through a mutual agreement. So through mutual agreement, through what you are calling mutual agreement. Through what you are calling lapse of time. So time has come to an end, lapse of time. So through lapse of time, also this particular kind of contracts can come to an end by operation of law. By operation of law. By operation of law. You can give an example, e.g. like how can it automatically come to an end? So for example, in this case, we can be able to say, e.g. winding up or liquidation of the insurer. Liquidation of the insurer, winding up or liquidation of the insurer. Winding up or liquidation of the insurer. Then sale of the subject matter. Sale of the subject matter. Sale of the subject matter. So that house you're ensuring you sell it to another party. So breach of the conditions or warranties. By breach of the conditions or warranties, you can simply say breach of the terms. Breach of the terms. Breach of the terms. So that is number 6. So payment of the indemnity. For example, if you pay for the loss or you indemnify, or the insurance company does the payment of the loss. So it simply means that they have already compensated the insured party. So the contract will no longer be in existence because now in this case, they have already done the compensation. Then when you talk about mutual agreement, so just by simply agreeing, so you can mutually agree as parties. You can mutually agree as parties. You can mutually agree as parties that you want to be able to end or terminate the contract. So the parties may at any time agree to terminate or end that particular contract, end the contract. So you can just mutually agree, the insured and the insurer, that you no longer basically want to be under the contract. So you can be able to terminate or end the agreement. Lapse of time, for example, if it was just for simply for a period of 1 year, so you're taking up a health insurance policy or cover for a year. So once the year elapses, the policy comes to an end. So therefore, the contract will have come to an end. By operation of law, so by this one, we simply mean, let's say, for example, liquidation of the insurer. In this case, we simply mean you've taken a policy with, let's say, for example, Jubilee Insurance as a company. Then all of a sudden, you are told Jubilee is going under. So it will no longer be in existence. It is going to be liquidated or be wound up. So liquidation simply means the ending of life of a company. So if they end the life of Jubilee and yet you are basically insured by Jubilee, so one of the parties is no longer there. It's like, hello? Yes?
Let someone in, please.
So you are saying in this case, what we mean by liquidation is like ending the life of the insurer. It's like death, natural death of, basically we're going to be able to say just death of the insurance company. It is no longer there. So if the insurance company is no longer there, then there's no agreement because the other party is no longer there. So by operation of law, then the contract will come to an end. Sale of the subject matter. So you sold that house that you had actually taken up insurance cover for. You've sold to another party. So now in this case, you don't have an insurable interest in the house. So if you do that, basically the insurance contract will come to an end. It will come to an end. Then breach of the terms. For example, you are saying you are supposed to act with utmost good faith. So if you fail to basically act with utmost good faith and it is discovered by the insurance company later, then they have a right to be able to end or terminate the contracts. Or for example, in this case, if you discover as the insured party that the insurance company was lying to you with regard to some of the matters or services they provide, then you have a right to be able to terminate because they have breached the terms under the contract, the terms under the contract. Failure to probably act with utmost good faith and of course give the right information that basically will lead to the formation of the contract, that will lead to formation of the contract. So so those are the ways through which a contract of insurance can actually be terminated. So that is the end of that particular topic known as the contract of insurance, the contract of insurance. So we've been able to define, look at the essentials, seen the principles, how is it actually formed, and of course, how it can actually be terminated, how it can actually be terminated. So I want us to look at, I think probably it's the last contract that we're going to look at. So it is known as the contract of indemnity and guarantee. The contract of indemnity and guarantee. So there's a topic there, the contract of indemnity and guarantee. So the contract of indemnity and guarantee. So these are two contracts that are almost similar or basically related. So that's why we'll be able to look at them just once and for all. So we're going to look at what is an indemnity contract? 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 Then we'll be able to look at the parties under an indemnity contract, then the essentials of an indemnity contract, the essentials of an indemnity contract. Then we'll be able to also look at the meaning, or basically what is a contract of guarantee, what is a contract of guarantee, what is a contract of guarantee, then see who are the parties under a contract of guarantee, parties under a contract of guarantee. And then also we'll be able to look at types of contracts of guarantee, types of contracts of guarantee. Then we'll also be able to look at the rights and duties of parties under a contract of guarantee. Under a contract of guarantee. Then we'll be able to see the termination. How does it come to an end? Termination of a contract of guarantee. Termination of a contract of guarantee. Termination of a contract of guarantee. So that is what you're going to be able to look at under this particular topic we are calling contract of indemnity and guarantee. So just as we've been looked at it under insurance contract, you've said that what we mean by indemnifying or indemnity, it is simply basically where you compensate another party. You compensate another party in case of any loss actually occurring. If you do such, we say you have done what you are calling indemnify. You've indemnified. So under the contract of indemnity, what normally happens, we have two parties. So there's usually the indemnifier and a person known as the indemnity holder. So the indemnifier is actually the party now who actually compensates or actually indemnifies the indemnity holder in case of any loss. In case of any loss, then we'll have a person known as the indemnifier actually compensating the indemnity holder. So what we are saying, under the contract of indemnity, there are usually two parties. So there is the indemnifier and the indemnity holder. It is simply a contract whereby one party gives the assurance to the other party that in case of any loss under a particular agreement or a certain agreement, then he'll be able to compensate him or her for the loss. So the person giving the assurance to be able to compensate the other party for the loss is known as the indemnifier. And of course, the other party being compensated is known as the indemnity holder. It is where a party actually agrees to compensate another party in case of any loss occurring at a certain future date out of a certain contract or agreement. If that loss actually occurs, then he gives the assurance that he'll actually be able to compensate this particular party. So the person giving the assurance is the one you are calling the indemnifier, the one compensating. So while the one basically being compensated is the indemnity holder, So these particular two contracts are almost similar, but a bit different in certain ways. For example, under contract, we are seeing the contract of guarantee. So guarantee, as you've known it, is, for example, you get a loan from the bank, so they'll ask you to bring a guarantor, So that agreement you're entering into with the guarantor, it leads to the formation of what you are calling a contract of guarantee. Under contract of guarantee, there are usually three parties. It's not like these other normal contracts we've seen. A contract of guarantees are a bit unique because in that particular contract, we'll have three parties. We'll have the bank itself, and of course, we'll have you, the person borrowing the money, and of course, the guarantor. So three parties actually enter into an agreement that in case of default of payments by the borrower, then of course, in this case, we are saying the guarantor will be able to pay the bank. So under contract of guarantee, there are usually three parties. So we have the borrower, or sometimes they call him the creditor, or in this case, or we call him the debtor, sorry. So the borrower is known as the debtor. So while the bank is actually the creditor, and of course, in this case, the one giving the assurance to pay for the loan in case of default is the guarantor. So under a contract of guarantee, it's not like a contract of indemnity whereby we'll have two parties. There are usually three parties. And each and every party in this case will actually be will have a duty to be able to perform in case of any loss actually occurring or failure to pay the amount. In this, we are saying the guarantor will be able to come in or step in. So that is basically what we mean by a contract of indemnity, and in summary, a contract of guarantee, So let me just see if I can be able to get some few questions with regard to maybe agency and of course the topic that we just covered before this one, so that we can be able to see whether we can be able to see how they are tested. So let me get the past papers, then I can be able to share. So we can have that question 5 is question 1B. Then also we can be able to look at question number 3A. You can look at question number 3A. So we can start with question number, it's from this particular setting, May 2019, question number 1B. Then also we can be able to look at, I think, question number 3A. So we can have Mercy. So we can have Mercy read for us question number 1B. Question number 1B, it says, is Mercy there? So maybe we can have Boaz. So Boaz, you can read for us question number 1B.
Explain
1B says, go ahead.
1B, explain 4 features necessary for agency of necessity to exist.
Yes, it says explain 4 features necessary for agency of necessity to exist. So I think this one is from the topic of contract of agency. So where we learned about how agency can be created. So there are several ways we said agency can actually be created. If you can remember very well, we said, for example, through an agreement, out of necessity, through ratification, through cohabitation. So you can remember very well what we learned about how agency is created. So an agency, we said, is a contract between 2 parties, the agent and the principal. How is agency created? So one of the ways we said agency can be created is out of what we are calling necessity. Out of necessity, a relationship between an agent and a principal can arise. The best example we gave is, let's say, for example, if a disaster actually happens or actually occurs, then probably it simply means that out of necessity, someone can actually basically come out to be able to assist or actually help. So they're asking, under what circumstances, under what features should they actually be present for agency by necessity to actually to occur or actually exist? So maybe I can just show you so that we are on the same page. So there we have it. So it can happen in 2 ways. You can have commercial or maybe domestic. You can have commercial or domestic. So Mercy, just still Mercy. So maybe you can take us through agency of necessity. Just read for us agency of necessity from the start there.
Agency of necessity. This is a category of agency created by law in circumstances of necessity where one party is deemed to have acted as an agent of another. Agency of necessity arises in 2 circumstances, namely commercial and domestic. Commercial agency of necessity. According to Lord Simon in China Pacific case, commercial agency arises where a party is in possession of another's goods, whether perishable or not, and an emergency arises requiring immediate action in relation to the goods, and it is impossible for the party in possession to seek instruction from the other. This was also the case of.
You can just skip that and go to the next paragraph.
Okay. The party must therefore act in good faith as owner. for the urgency to arise, these conditions are necessary. There must be a genuine emergency necessitating action in relation to the goods. It is impossible for the party in possession to seek instructions from the owner. The party in possession must act in good faith for the benefit of the other party.
Yes, so you can just go up to that particular point. So just go up to that particular point. So you can see what they are saying there, that this agency, what you are calling commercial agency, for it to arise, those particular key essentials are actually very important. That there's no way you're actually able to get instructions from the owner of the goods. So it can only arise under that particular circumstance. Then when you are acting as the agent, you must act in good faith. So he's not there to be able to see what you are doing. Probably it could be goods and probably you are carrying some of them, taking to your home, locking them there, hiding them there, stealing them. So the party in possession must actually be able to act with what you are calling good faith in the best interests of the owner of the goods. So there must be a genuine emergency. For example, there's a disaster like fire and you can't get instructions from the owner of the goods. Since that one actually arises, then an agency might actually arise whereby you try to salvage the goods on behalf of the owner of the goods. So because you are saying it arises in circumstances where there is actually what you are calling emergencies, and you can't actually be able to maybe get instructions from the owner. Probably you could get instructions from the owner and he says, don't do anything, just leave the goods to be destroyed. So, but in this case, you are not actually able to get the instructions. So therefore, maybe as a person of best interest, or basically a person who's actually probably honest, so you salvage the goods on behalf of the owner. So those key essentials that I've just highlighted there, so they are actually very important for agency by necessity, especially under commercial agency, to be able to arise. Then it can happen domestically. So this one is actually almost similar to what you are calling agency by cohabitation. So under the common law or under the traditional English law, a deserted wife was regarded as an agent out of necessity with the authority to pledge her husband's credit for necessaries. What do they mean by this? You simply go to someone and simply pledge the credit of your husband, such that you say that I'll take up the goods and of course my husband will actually be able to pay. So by your actions, basically you're acting like the agent of your husband. So that used to happen under what you are calling the common law or the traditional English law. So I've been deserted by the husband. She must be free from any blame. Then her authority is restricted to pledging her husband's credit for necessaries. What they mean by necessaries in that case, necessaries are basically goods that you can't do without. They are simply essential or basic needs. By essential or basic needs, we mean, for example, let's say, for example, clothing, food, or maybe shelter. So in this case, under the common law, then you're saying the wife could have basically pledged the credit of the husband in terms of having to get these particular goods on credit with the assurance that the husband will actually be able to pay. So those conditions are actually basically necessary for agency, either domestically or basically agency, either commercially, with regard to agency by necessity to be able to arise. So so those are basically the conditions, or basically the conditions that should actually be present for agency by necessity to arise. Agency by necessity to arise. Agency by necessity to arise. Huh? So those are the answers to that particular question. So you can either approach it under commercial agency out of necessity, or basically you can approach it under domestic. So this domestic is almost similar to what you are calling cohabitation, whereby a husband and wife are staying or living together. So I want us to look at that other question. So that is question number 3. You can look at question number 3, or probably let's look at just question number 3. So Boaz, you can take us through question number 3.
It says, with reference to the law of tort, explain the legal principle in the rule of Rylance versus Fletcher. Roman 2, describe 3 differences available in the person sued in an action brought under the rule in A, Roman 1 above.
Part B.
Part B says, in relation to the law of contract, explain 4 elements of an enforceable contract. Part C, examine the principles relating to contractual capacity of minors.
Yes. So probably that question number 3, probably I could leave it as an assignment. So just go and check what the rule in Ryland versus Fletcher actually states. It is basically under the law of tort. It talks about strict liability as one of the torts. So you'll be able to discover more. It's usually a very common question, Ryland versus Fletcher. So just take it up as an assignment, although I'll be able to also tackle it or handle it probably in our next class also. But go and try to be able to discover what this particular rule actually states. The rule in Ryland versus Fletcher, it talks about what we call a tort known as strict liability. And of course, there are also the defenses there. And of course, they are what we are calling the key elements that should actually be present for strict liability to arise. So I think this one we learned under the law of torts. But now let's just look at part B. In relation to the law of contract, explain 4 elements or essential elements of an enforceable contract. So 4 essential elements of an enforceable contract. So I think this is the first thing that we learned when we are talking about the law of contracts. So what are the key elements that must be present for a contract to be enforced? So what are the key elements or key characteristics that must be present in each and every kind of a contract? So there must be an offer and an acceptance. So there can't be any contract without what you are calling an offer and an acceptance. There must be what you call a consideration. There must be what you call a legal, something that is actually allowed under the law as consideration. What we mean by consideration is the price each and every party actually pays under the contract. In this case, we mean, let's say, for example, if it is you that you basically entered into an agreement with RCM Online College. So there's what the college is actually giving, and there's what you as a student you're actually giving. So the fee that you're actually paying is the consideration. The tuition we are providing is actually the consideration at our end. For each and every kind of a contract, there must be that particular element. There should be what we are calling consideration, the price that the other party actually suffers or basically has to pay. Then it must be leading to what you are calling a legal relationship between the parties. So you must not be entering into an agreement that is basically not actually allowed or basically outlawed under the law. So maybe we can just have a look at them very quickly so that So there must be an offer and an acceptance. So there must be a legal relationship between the parties, intention to create a legal relationship. So that relationship between the parties should actually basically something that is actually allowed under the law. There must be a lawful consideration. So the price that is being paid is a lawful consideration. There must be the capacity or capabilities of the parties to be able to contract. For example, in this case, minors, so they have certain incapacities whereby they can't enter into each and every contract. The contract should actually be entered into through what we call free consent. So it must not actually be through what we are calling coercion or being forced. So no one basically forced you to join the online classes. So basically it was voluntarily by yourself. So no one actually basically forced you to enter into the agreement. So there shouldn't be any form of coercion or undue influence. It should actually be through what we are calling free consent. Then there should be a lawful object or basically lawful subject matter. So that subject matter that is forming the agreement is something that is actually basically allowed under the law. So if it's something that is actually outlawed, so let's say, for example, contract to do with maybe drug trafficking. So the subject matter here or the object here, the drugs are actually basically outlawed by the laws of the land. So therefore, it can't lead to an enforceable contract. What do you mean by this? For example, if there's breach, whereby one of the parties fails to pay for these particular drugs during drug trafficking, then there's nothing you can be able to do because you can't go to the court. So that kind of a contract is not actually enforceable. It can't be enforced under the law. It can't be enforced under the law. So they're also asking about the legal provisions with regard to contracts with minors. So we are saying that minors are simply persons who have not attained the age of 18 years, the age of 18 years. So they can only, they don't have the capacity or capability, but under exceptional circumstances, they can actually be able to enter into contracts. They can be able to enter into contracts. For example, number one, if this particular kind of contracts for them can only be valid if number one, this kind of contracts are actually basically to acquire or be able to get what we call necessaries. So I think I've already explained what are necessaries. So if a minor enters into an agreement to be able to acquire necessaries, then such kind of a contract with a minor is actually enforceable. So what do you mean by necessaries are things basically this particular minor cannot actually be able to do without. Other thing whereby, or other kind of contracts whereby they are valid with regard to minors are contracts of service which are actually beneficial to the minor. For example, if the minor basically is engaged in a contract to provide a particular service, or maybe a corporate entity that is likely to be beneficial to the minor, then such kind of a contract can actually basically be seen as being valid. For all the other kind of contract, they're actually void or actually avoidable under the law of contract. So minors, they don't have the capacity. They only have the capability. For example, number one, if they're entering into an agreement or contract to acquire necessaries. Number two, if the contract is actually a contract of service, which is beneficial to the minor, So you can be able to check that also under the law of contract, just the law of contract, you'll be able to get those particular notes talking about the capacities of different parties of being able to contract or not to contract. For example, discover something about persons of unsound mind and drunken persons. Do they have the capacity to enter into a contract? Can you be able to enter into a contract, you as a person, with a person of unsound mind or a person whose thinking capacity is not proper? Which kind of contracts are basically valid in such a case? So discover something about drunken persons and persons of unsound mind. For minors, I've already explained. In such a case, for a minor, they don't have the capacity, or all the contracts they enter into are actually basically void or actually voidable. They can be avoided. But the only contracts which will actually be valid for minors are contracts to acquire necessaries. Number two, contracts of service which are beneficial to the minor. In such a case, if they enter into such kind of contracts, then they become valid contracts which can actually be enforced. For example, if there's breach to provide this particular service by the minor, then you can be able to take action as the other party under the contract. If there's breach, let's say, for example, in this case, to be able to pay for the necessaries which have not been paid by the minor, then you can be able to take action. But for all the other kind of contracts, then they don't have the capacity to be able to contract persons who have not attained the age of 18 years, persons who have not attained the age of 18 years. So I think that's it for today. So next time, I think probably we'll wind up with this particular topic of contract of indemnity and guarantee and see how far we'll be able to go. So probably if we finish this one, we'll start the law of property, the law of property. Then we can look at negotiable instruments, let alone negotiable instruments, and see how far we'll be able to go. So make use of the past papers. Make use of the past papers in your revision as you carry out the revision. Make use of the past papers so they'll be able to guide you a lot in terms of doing your revision. Don't just sit there reading the notes. So the notes might become very boring, not really interesting, but probably if you use the past paper, the revision basically will be more interesting. So just get a past paper, try to look at it, compare with your notes, and I can assure you basically the notes I've shared, they have like almost all the content for most of the past paper questions. So rarely you'll basically miss the content with regard to the past paper questions from the notes I've actually shared. You'll get the content with regard to the past paper questions. So this particular unit is very wide. So sometimes the notes are usually very wide, a lot. But as I've advised you, probably make use of the past papers anytime you want to revise. It will make your revision become very easy and very interesting instead of just having to read like the notes throughout. So you might find that you've actually only been able to cover like a topic within a day, but probably if you use past papers, you could actually easily cover a lot in terms of the content, like maybe probably like 3 topics that you've actually been able to revise. So unless there's a question, I would wish to end the class there, and I think we'll meet next time. Remind me next time that question of Ryland versus Fletcher that I've given as an assignment. Probably we can be able to start with it before we continue with anything else. So I think we can end there unless there's a question. So I can see Lenny. Lenny, are you there? Lenny, do you have a question? Any question? I can see most of you had trouble in joining the class today. I don't know what was the issue, but I think I've tried to admit most of you in the class. And I think all of you have been able to join the class. I can see Lenny is quiet. What about Ruth? Ruth, are you there?
Yes, sir.
Yes, do you have a question?
No.
Or not at the moment?
Yeah.
Okay, are things becoming easier or things are looking a bit tough towards the exam?
Sahi naelewa.
Unaelewa?
Yeah.
Yeah, so just keep on revising as I've advised. Things will be better towards the exam. So probably if we finish up very early, we could also be able to cover a lot in terms of revision, but I think we'll be doing it as we go on, just the way I'm doing, to be able to cover some of the areas in terms of past paper questions and how to be able to answer them. I can see Sasha. So Sasha is here. Sasha, are you there?
Yes.
Okay, Sasha, you joined the class late. Sorry about that. And I think you had some troubles in joining the class. But I hope you've been able to catch up with what you've been able to learn.
Yes, I hope so.
Okay.
Yeah, thank you.
That's fine. Okay, fine. So I think we'll meet next time. So I wish you all a good night. And I think we'll meet next time in our next class.